Teleflex, Court of Appeals, Division 1, now.
Thank you. Please be seated. Good morning. We're here for oral argument in Emmons v. Teleflex, CV19 0678. These proceedings are being streamed live via YouTube. There will be a recording, so if you'd like at some point to go back and review the case or your performance or whatever the case might be, then you may feel free to do so. Please identify yourselves and your client at the beginning of your argument for our recordings. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. And you've probably been advised by our bailiff that we have switched the clocks from what we typically do, just so that from your vantage point you can see your time. We have read the briefs and have discussed the case previously. Please remain seated at your tables during your argument, because we have moved the microphones to your table, so if you make use of the podium, we will not be able to pick up your voice with the microphones. You may remove your mask during the time of your opportunity to argue if you so desire. And also you will note that Judge Morse is not here today. He had a death in the family, and so he is absent for that reason, but he will watch the recording of this of today's oral arguments and participate in the final decision. So with that, counsel.
Thank you. May it please the court, my name is Mick Levine. I'm counsel for plaintiff appellant Miss Christine Emmons. I bought a brand new cell phone. Went to the store, purchased it new, and a week later it blows up in my hand. We can infer without actual direct evidence that a cell phone purchased brand new shouldn't blow up in someone's hand. Now, that's the basis of our case. It's based upon circumstantial evidence. Circumstantial evidence is the indirect evidence that proves a fact that's necessary in order to prove our case.
So that's not really your case, because the cell phone came directly to you from the manufacturer. Here, there's a third party involved, and the question, and correct me if you disagree with me, that's fine, but the question is whether or not the nurse properly used the medical device, correct?
I think that is a question, but not the question. So let me see if I can...
How is it not the question?
Let me see if I can answer that by example with the cell phone. When I purchased this cell phone, I purchased it from a retailer. The retailer puts a battery into this cell phone, and it blows up in my hand. Now, I have two claims. I have one against the manufacturer for a manufacturing defect, because normally a cell phone shouldn't blow up in your hand. But I have another one against the retailer, because perhaps they put...
Do you really have a claim against the manufacturer if there's not a dispute in your hypothetical that the battery was clearly inappropriately used?
And I think the word that the cases utilize is solely, and that's, I guess, what the question is can we say that the third party, in my example, the retailer, in this case the nurse, was solely responsible for the catheter breaking off in Miss Emmons' back? That involves comparative faults. And as we discussed in our briefs, the premium manufactured systems case talks about how we have to compare the fault of the parties. In order to compare the fault of the parties who are involved, we have to have a determination after a trial, after a hearing, by the trier of fact. We can't just assume that one party is solely responsible for what occurred. And that's what happened here, is that the court determined that one party, the nurse, was solely responsible for what occurred. But can't we have two causes of something going wrong? such as this
Didn't the
catheter.
court really determine that you had no evidence that one party, that the manufacturer was solely responsible? Wasn't it a determination, not that the nurse was not, but that you had no evidence to show that the manufacturer was solely responsible?
Well, I don't have to prove either party was solely responsible. That's their burden. They have to prove that the nurse was solely responsible and not the manufacturer. But what evidence I did have that the manufacturer was responsible is that this was a brand new catheter being used for the first time and it broke in someone's back. Now, one thing or another may be believed here.
Did the warning on the catheter indicate that if there was excessive force used, that it could cause a problem?
Could, yes,
I
and
mean,
the warning
manufacturer-
did indicate that that was a possibility.
So the manufacturer was aware that if a third party inappropriately used the catheter, it could be a problem.
The manufacturer was aware of that, yes.
And put the hospital, the nurse on notice of that.
I can't say what the nurse was or was not on notice of. What I can say is...
Does it matter against the manufacturer? Let's say the nurse didn't read any of the instructions for the catheter. The hospital had never gave anybody anything. How does that reflect on the manufacturer?
Let me see if I can understand your question, make sure that I understand this properly. What you're saying is that if the manufacturer provided a warning to the nurse or provided a warning meant for whoever was to utilize it, that would relieve the manufacturer of liability. I think what you're talking about here is a concept that wasn't argued in any of the briefs, which is the learned intermediary doctrine. And I don't believe that was brought up in this particular case.
Did you originally have a failure to warn claim?
We did, yes.
But you conceded that was no longer viable?
That's correct. Our sole claim here is manufacturing defect claim. And the way that we prove that there was manufacturing defect is to say that under normal circumstances, these things don't break the very first time that they're utilized. Our burden is to...
Let me interrupt you for a moment. In your hypothetical where you buy the cell phone and the third party, the store, puts a battery in it and it blows up, what if the telephone comes with a warning that says, do not put the battery in backwards, it will blow up?
And if the battery was put in backwards, then that might be an issue. But here we don't know that the battery was put in backwards. Or if I may, comparing it to our actual situation, we don't know if the nurse used excessive force that caused this fracture. What we know is that we made that allegation in our complaint based upon information and belief. But we don't have anything definitive indicating that that's what occurred to cause the fracture in this case.
I thought the nurse indicated in her notes that she had used force that there was force used to remove the catheter.
First, let me talk about procedure.
No, answer my question first, and then you can.
The nurse indicated in her notes that she encountered resistance. That's what the nurse indicated in her notes.
So what did your expert say?
We didn't have an expert on this particular issue because we were relying on the circumstantial evidence in order to show that a catheter does not normally break in a person's back when used for the first time.
Oh, and jurors should just commonly know that.
I think a juror can understand that things don't break the first time that they're used. That's not supposed to happen.
Well, that may be what you wanted them to believe, but that may not necessarily be true, even under the facts of your case. Unless you can have some evidence from an expert that would say these normally wouldn't happen, but it had to be with excessive force, or the contrary to that.
And I think what we're getting into is competing inferences. One thing that we have is that circumstantial evidence indicates that normally a catheter does not break on its first use. I think that anybody would understand that the first time a product is used, it shouldn't break. What they're talking about is that, well, the nurse must have used excessive force in order to break it. But isn't that a decision for a jury to make a determination upon after they've heard the evidence? First inference
but
is...
Doesn't the manufacturer tell us that, yes, this catheter, brand new, can break if removed improperly?
Can break if removed improperly, yes. But there's no evidence in this case that it was removed improperly. About the only way that they get to that is the nurse's note saying that she encountered resistance while trying to remove it. That doesn't necessarily mean that she used improper force in order to remove it. It just means that she encountered resistance. That's all that it means. We can't assume that the nurse used excessive force causing this fracture. What we can do is we can assume that normally a catheter doesn't break the very first time that it's used.
You know what they say about people that assume?
Yes, of course, Your Honor. But what I'm getting at here is an implicit assumption that can be made based upon the circumstantial evidence that's provided. But back to the example with the cell phone, it shouldn't blow up first time that it's used or within a week of its use. And we have plenty of cases that indicate as much.
I'm buying your cell phone argument for the very reasons that the question came from Judge Cruz is, you know, if there's a warning that says you put this in backward, it's going to blow up in your hand, and the third party puts it in backwards and it blows up in your hand, I'm not sure how that the manufacturer said all this.
Under those particular facts, Your Honor, I think that what you'd need to know is that the third party put it in backwards, and that's what's missing in this case. We do not have the nurse saying that I tugged or that I did something inappropriate in order to remove this catheter. What she indicates in her notes is that she encountered resistance.
Well,
That's
she says
it.
she encountered resistance and ultimately removed the catheter.
Yes.
She didn't leave the catheter in or reposition the patient.
From what I can tell from the notes, what she did was that she encountered resistance. I can't tell you
And
whether...
removed the catheter nonetheless.
And remove the catheter, but I can't tell you whether she repositioned the patient or used appropriate methodologies in order to remove that catheter after she encountered resistance. That's simply not in the record.
Let's get into that because in your brief, you talk about the reply
Yes, Your Honor.
and not having the ability to depose the nurse.
Yes, Your Honor, and that was one of the things that I was going to talk about regarding the procedural posture of this case. The motion that we received was that we didn't have any allegation of a specific defect with this device, with the catheter. We responded to it saying that using circumstantial evidence, you can assume that a brand new item should not break. The reply that we got included medical records and information from our client's medical records that indicated this information regarding the nurse.
Who's provided those to the manufacturer?
Who provided what?
The
I'm sorry.
medical records. Who provided those medical records to the manufacturer?
We provided those in disclosure, Your Honor.
So you had all of those records. There's not a dispute about it.
As far as having the medical records, yeah, we had a copy of those medical records. Yes, Your Honor.
Did you ever ask for, once they filed the reply, did you ever ask to have it delayed while you deposed?
I don't know that Rule 56D permits or Rule 56 permits a SIR reply. I've never seen that in the rules.
Well, don't the rules specifically authorize attachments to a reply?
I don't believe that the rules specifically authorize additional information to be brought up for the first time in a reply. My understanding is that new arguments are not supposed to be made in a reply. New arguments are supposed to be made in your initial pleading, to which we responded, and then we received new factual information for the first time in the motion practice in the reply.
Hold on. Rule of Civil Procedure 7.1A says, affidavits submitted in support of any answering memorandum or memorandum in reply shall be served together with that memorandum, and the moving party shall have 15 days after servants, and then it goes into 56C2, this says the moving party shall have 15 days after service of the response in which to reserve a reply memorandum and any supporting materials. So if the rules anticipate that you're going to be able to provide supporting materials, isn't it incumbent on the notion that I didn't know about these supporting materials, which you can't say in this case, because you knew about them. They were your materials.
My understanding of how motion practice works, Your Honor, is that they have to make a prima facie showing in their initial pleading that they're entitled to summary judgment. Our response was focused on their original filing. They filed a reply that included new arguments that were not made in their original filing. I don't have an opportunity to respond to a reply. The rules don't permit a response to a reply. And I can't anticipate what it is that they're going to bring up before they've brought it up. Unfortunately, I can't see into the future like that. What I can do, though, is that I can face what I can face. I don't believe that I can ask for Rule 56D relief after a motion is fully briefed. I don't believe that 56D permits that. They permit relief for me to file a response to their motion, which we did, bringing forth the circumstantial evidence that this was a brand new item and that it failed on its first use.
Yeah, see, it seems to me, and again, and you can correct me if you think I'm wrong, is the notion that in this case, and I'm going to go back to the crux of the issue is whether or not the nurse was negligent. Because if she was not negligent, there is a clear manufacturing defect, right?
I don't necessarily agree, and
But let me finish. So
can I just explain real quick why I don't agree?
we can come back to it. But you were aware of the nurse. Did you ever depose her? I mean, you sued her.
She was not deposed in this matter.
So you
And-
never took the time or effort to depose the nurse, but it's fair for you to say that they included her materials that you provided to them.
She wasn't deposed in this matter because her deposition wasn't necessary for us at the point in time that we were in this particular case. Your Honor, this was an arbitration-eligible case, and in arbitration cases, it's quite frequent that you want to keep the costs and expenses down. And until we received their reply to the summary judgment motion, deposition of the nurse was not something that we felt was necessary under these circumstances. Now, going back to your original statement regarding the negligence of the nurse, I have to go back to the premium manufactured systems case, which says that you compare faults of parties in a manufacturing defect case, just like you do in any other case. So in order for this to be a manufacturing defect, I believe that you have to find the nurse solely responsible for causing the fracture. Not partially, not a bit, but solely the deciding factor. And under UCATA, you have to compare the fault of the different parties. And in fact, I think we even have a constitutional provision that says that comparative fault is always a question for the trier of fact. Thank you. I'll reserve the rest of my time.
All right, thank you, counsel.
Good morning, and may it please the court. My name is Tracy Fowler with Snell and Wilmer. I'm here with Ashley Weiberg. We represent Teleflex Incorporated. Judge Smith correctly applied the law and acted well within his discretion in granting our motion for summary judgment in this case. And I think the court has zeroed in on the critical issue here. And I'll address it in the context of what counsel just said, which is his argument is we should let the jury compare fault here. But the fundamental question is there evidence in the record that would support a jury finding of fault on either of the parties that they want to point the finger at? That's their burden. And if they can't come forward with evidence sufficient at the summary judgment stage, then summary judgment has to be granted against the plaintiff. In this case, as the court has noted, there is zero direct evidence of a manufacturing defect. They didn't ever even try to characterize what the manufacturing defect was or how it came to exist, or explain in any way that how it functioned. They simply said we're allowed to assume from a negative outcome in this medical procedure that it was the result of a manufacturing defect. And while there is some limited law that allows that in some circumstances, those circumstances aren't present here, so that law isn't applicable. The reason for that is because the record contains evidence that would allow a jury to allocate, to explain this failure and allocate the fault entirely to the nurse who handled the removal of the catheter. And those medical records, which were cited in our moving papers in the original motion for summary judgment, the nurse indicates, and the attending physician who also recorded notes indicates that she encountered resistance when she attempted to remove the catheter, and she proceeded to pull it out after that. And if you contrast those descriptions of what she did with the instructions for use, which were provided by the manufacturer to the hospital. They say specifically, if you encounter resistance, stop. Do not tug on it, do not pull on it. There's a series of steps that the nurse or the attending physician are required to take at that point as an alternative means of trying to remove the catheter. It's not an unknown circumstance. It's one that's inherent in the design and utility of this device. It has to have a certain amount of tensile strength, but also some flexibility, and these are all engineering trade-offs that result in it having certain performance limitations. And the manufacturer knows it. They communicate that information to the user. So it's important for the user to use the device, and including the process by which it's removed, in accordance with the instructions. And had the nurse done that here, and it reflected that in the record here, then there wouldn't be a basis for considering that as an alternative cause of this. But the record actually is explicit in describing the procedure in a way that directly contravenes the instructions for use. We presented that information to the trial judge in the moving papers. It was not a surprise that showed up for the first time in the reply brief, and it certainly wasn't a surprise at all, since it was known, it was in the medical records from day one, long before we were ever brought into the case, because that happened by an amended complaint. At no point in time did counsel choose to develop additional information about that. He could have deposed the nurse at any point in time during which he was proceeding against only Banner. He could have done it at any point in time after he amended his complaint and was proceeding against Teleflex. He opted not to do that. We asked him about inspecting the device to see if consultants could determine any more information about what happened to it. He chose not to do that. And when the discovery period ended, we realized he had no evidence of a manufacturing defect, so we moved for summary judgment. We cited those provisions in the medical records and pointed out that the record would support a jury in concluding that the nurse and her failure to follow the instructions for use account for this negative outcome in this medical procedure, and explain why the catheter was not removed fully intact. At that point in time...
Does it solely explain it? I mean, it seems to me that there is some persuasive force in the argument that a jury, upon hearing the evidence presented, could determine the percentage of fault may be pretty low for the manufacturer.
Well, I would suggest, Your Honor, that the record evidence, again, showing the description of the procedure and its direct contravention of the instructions for use, would allow the jury to conclude that she simply failed to follow the instructions, and that had the expected result of the catheter separating before it was fully removed, and therefore attribute fault solely to her. The question then becomes, is there some evidence in the record from which they could say that an additional contribution came from some manufacturing defect? And the answer is zero. They never tried to describe or characterize any kind of defect. They never provided any information about how it came to be or what it was or how it actually played a role in this incident. There's zero evidence in the record that would allow a jury to say maybe the design or manufacture of that device played a role. That would be pure speculation by a jury.
What about plaintiff's position that the mere fact that it separated can be evidence that it was defective?
Well, it could be in the absence of another cause. What the restatement teaches us, and the treatise and the authorities that the trial court relied on, is if there is no evidence of another cause, then you may resort to an inference that something went wrong with the manufacturing process, and that explains why there was a failure in these circumstances. That's not our case, of course, because we have direct evidence in the record of another cause. So that circumstantial evidence is not appropriate. That the inference that they want to draw through circumstantial evidence is not appropriate in this case. The bottom line question here is, did the plaintiffs come forward at the time we moved for summary judgment with sufficient evidence or any evidence of a manufacturing defect? And the answer is no, because they had no evidence of that. They want to fall back to this circumstantial evidence inference, but that only comes into play if there's no evidence in the record of an alternative cause, or alternatively, they could have brought an expert to say, yes, we can see that the nurse encountered some resistance. I've analyzed the situation, and here's why that doesn't really explain it. And in contrast, here's my explanation as to why there was a manufacturing defect. That might allow them to utilize that circumstantial evidence if they could negate the other cause. But here they offered no evidence at all. In fact, their original pleading and their amended pleading also characterized the nurse as having been negligent with respect to the removal of the catheter. That was never changed in an amended pleading, so that's their position as a matter of pleading. They offered zero evidence to suggest, to negate or account for the nurse's improper use of the product in the removal. So that's the state of the record at the time Judge Smith was confronted with this.
So I hear you saying that in this type of case, there has to be an expert that would draw the dots between manufacturer defect versus just inappropriate use by the nurse. Is that true?
If the plaintiff chose to try to negate the evidence in the record that this nurse used an improper removal method, that would have to be done through expert testimony, because it's not, as the court observed earlier, it's not the kind of thing that's within the normal understanding of a juror. I mean, a juror may just assume, why can't we have a catheter that is foolproof and you can insert it, introduce an anesthetic, and then pull it out without any problem? Well, it's more tricky than that, as we all know now. And they have limitations in what they can do, and they have to be handled just right to serve that important purpose and also be removed properly. So that all of that would have to be addressed by an expert who understands the engineering and the design considerations in these products, the operational limitations that are encountered. None of that is common knowledge to a juror or anyone else who isn't trained medically or scientifically in those products. So if that was the avenue they chose, which was to negate the evidence, they would have to do it through an expert. You know. And again, this is a device the device was available for inspection. We're not in one of those cases where the device blew up or somehow became unavailable and we're all at a loss to figure out what happened, so we have to resort to an inference. They could have easily had a consultant examine it and come forward with whatever his conclusions were, but they chose not to do that. They simply wanted to rely on this route from A to Z through an inference that, without having satisfied any of the intermediary steps, which would require them to show the absence of evidence of another explanation or come forward with their own expert testimony to negate that. They didn't either. I think that's, unless there's some specific question, Your Honor, that I can answer, I think that addresses the points I wanted to make. Thank you.
Thank you.
Looking at my time to see how much I have left, let me see if I can be brief. What was available in order to inspect was the end that came out of the patient, not the pieces that were inside the patient. Obviously, we can't have somebody inspect those. What the specific warning is in the instructions is never tug or quickly pull on catheter during removal from patient. Now, I don't see anywhere in the records where it says that this nurse tugged or quickly pulled during removal. All I saw was, and all that the defendant said is that she encountered resistance. That doesn't mean that she tugged, that doesn't mean that she pulled on the catheter, and that doesn't mean that she was negligent, although she could be, partially. But what I'm hearing from the defendants is not what Arizona case law is, which is it must be one or the other. We have the ability to compare fault. That's a jury question. The jury in this situation, or the arbitrator actually, because this was an arbitration eligible case, they have the ability to weigh these competing inferences. This thing broke on its first use, the nurse encountered resistance. They are the ones who are supposed to make that determination. Only if there's no evidence whatsoever from which a jury can reasonably conclude that this was the nurse, and only the nurse, who caused this problem, would summary judgment be appropriate. Given the circumstantial evidence that this was the first use of a catheter and that it broke, we don't have that much information in which a jury could never reach a conclusion on comparative fault here. I don't have anything else unless the court does.
No, thank you, counsel.
Thank you.
This matter is taken under advisement and we will issue a decision in due course. We are now at recess and we'll come back with the last argument at 11. Thank you.